Welcome back to the Constitutional Clarion. In my previous video, I explained how Section 6 of the Australia Acts 1986 can be used to entrench certain constitutional provisions. Manner and form constraints can be imposed so that laws respecting the Constitution, powers and procedure of Parliament can only be amended or repealed if approved by, for example, a referendum or a special majority vote of Parliament. This makes it really hard to change those laws in the future. But what about provisions that seek to entrench other things, such as the independence of the judiciary, the existence of local government, or political matters that have no relationship to the structure of the government or the Constitution? As they don't fall under Section 6 of the Australia Acts, is there any other source of power to support them? The short answer is we don't know, because the matter has not been settled by a court. There have been some theories that maybe Section 106 of the Commonwealth Constitution could play a role here, or a principle from a Privy Council case, which is known as the Ranasinghe principle, might work. But in the High Court's last substantive foray into the issue, which was back in 2003 in the Marquet case, it poured cold water over both of those possibilities. It concluded that, quote, the express provisions of Section 6 of the Australia Acts can leave no room for the operation of some other principle, at the very least in the field in which Section 6 operates, unquote. But of course, how the High Court would determine that field in which Section 6 operates remains uncertain. We simply don't know. The problem with entrenchment is that there is a temptation for governments to seek to entrench partisan political matters in laws so that when they lose government, a new parliament and a new government can't change that law unless it's approved by a referendum or a special majority. It's a way of one side forcing its own policies on the other side by preventing their future change. In this video, I'm going to compare how this issue was dealt with in New Zealand, Victoria, and New South Wales, all by Labor governments wanting to prevent the future privatisation of government utilities dealing with water and electricity. The reason for discussing the New Zealand position is because this issue was properly considered there and all the arguments were fully ventilated, unlike in Australia, where no one seems to care or notice, except for maybe me. Therefore, it makes it much easier to compare them against what's happened in Victoria and New South Wales. New Zealand is also interesting because it no longer has any higher law, such as the Colonial Laws Validity Act, which supports entrenchment. Its parliament, like that in the United Kingdom, is effectively sovereign. Yet in 1956, it legislated to entrench 6 fundamental democratic matters in its electoral law, which included the length of the term of Parliament, the minimum voting age, the secret ballot, and electoral redistributions. To amend or repeal those sections, a 75% special majority vote of members of the New Zealand House of Representatives is required, or the approval of the people in a referendum. The provisions were enacted with bipartisan, indeed unanimous, support. It was also accepted at the time that this entrenchment was not actually legally enforceable. It relied on moral and political force and was intended to establish a convention that would be treated as politically binding in the future. For this reason, no attempt was even made at double entrenchment because it would be ineffective. In practice, the New Zealand Parliament did comply with the entrenching requirement, with no amendments or repeals being made without following the required manner and form. In 1995, the New Zealand Parliament reinforced the manner and form requirement in its standing orders by requiring symmetry in relation to those special majorities. If a law imposes a 75% special majority for its future amendment or repeal, then it requires that same 75% majority in order for it to be enacted to begin with. The same symmetry, however, does not apply in relation to referendums. In November 2022, a Greens MP moved an amendment to a water utilities bill in the New Zealand Parliament, which prohibited the privatisation of water utilities and stated that this provision could only be amended or repealed by a special majority of 60% or the approval of the people in a referendum. The amendment was supported by the Ardern Labor Government and it was passed. The 60% figure reflected that need for symmetry because 60% was all that they could muster on the floor of the House at the time because it was opposed by two opposition parties. This sparked a huge controversy in New Zealand. Public law academics, in an open letter, pointed out that only core provisions that were fundamental to the system of representative democracy and had unanimous bipartisan support had been entrenched in the past. They considered that a politically contentious provision aimed at preventing future privatisation did not meet this constitutional threshold. They urged the government, quote, to think about the dangerous precedent that this legislative action may set, unquote. It would extend, quote, the use of entrenchment from a limited range of matters that are fundamental to our constitutional system to a matter of contested social policy, unquote. The New Zealand Law Society also issued a statement asserting that the entrenchment clause breaches a well-established convention observed by successive parliaments under which entrenchment provisions are reserved for significant constitutional matters outside the scope of general policy debate. It described the entrenchment clause as undemocratic. It proposes to bind the hands of future governments on a contestable policy position. The New Zealand government, interestingly, backed down. It recommitted the bill to the committee stage and had the entrenching amendment removed. The Labor Attorney-General, David Parker, stated that the government agreed that the entrenchment of the anti-privatisation clause is an inappropriate use of the entrenchment tool and that a serious constitutional mistake would have occurred if the entrenchment provision were not removed. He gave two reasons why the scope of those matters that were entrenched had to remain narrow. The first was democracy, that the people were entitled to throw out a government at an election and elect a new parliament that would change the law. This meant that the new parliament should not be stuck with the policy of a previous government that has been tossed out by the people. The second was that such a politically contentious entrenchment would likely result in a later parliament seeking to amend it by ordinary legislation and then getting the courts involved and raising the controversial issue of whether or not this convention, this political convention, had somehow crystallised into law. He concluded that Parliament should maintain the strength of the convention by not undermining it. The issue was so controversial that it was sent to a select committee for consideration, even though that amendment had been removed. It provoked many submissions about the appropriateness of constitutional entrenchment. The New Zealand Law Society wrote of the need to protect the legitimate sphere of constitutional entrenchment against political opportunism. Reasons expressed against permitting entrenchment of partisan policies included that, 1, it undermines the system of responsible government because the current government cannot be held to account for a law that it cannot change. 2, entrenchment is only legitimate when it's used to safeguard the integrity of representative democracy or protect some other constitutional principle, such as the rule of law, free and fair elections, and the separation of powers, not when it's used to protect contestable government policies against future repeal. 3, entrenchment can undermine the quality of laws, as laws that are extremely difficult to amend may cease to be fit for purpose, become out of line with community expectations, or result in unsatisfactory workarounds. And 4, it's likely to unlock the prospect of entrenchment being weaponised politically and may lead to the overuse or the retaliatory use of entrenchment, resulting in many contentious laws being frozen and unable to be amended. The contrast here with what happened instead in Victoria is quite marked. As in all Australian states, entrenchment in Victoria is supported by Section 6 of the Australia Acts 1986. But, as you know from the previous video, which I hope you watched, it's confined to laws respecting the constitution, powers or procedures of the state parliament. In 2003 in Victoria, there was major reform to the Victorian Constitution, with some provisions requiring a referendum for their future amendment or repeal, and others requiring a special majority of 3/5 of the members of each house. No symmetry was applied to insert those constraints. So there was no referendum or even a 3/5 majority involved, but because those amendments changed an existing entrenching provision in the Constitution, which was itself doubly entrenched with a requirement for passage by an absolute majority of each house, the law in 2003 was passed by an absolute majority. An absolute majority is a majority of all the members of the House, regardless of how many of them actually turn up to vote on that particular occasion. Ordinarily in Parliament, a simple majority is required, which is just a majority of those who happen to vote on that particular occasion. While these 2003 amendments purportedly entrench provisions that could largely be described as constitutional in nature, at least in the broadest sense of the term, many of them were not of such a nature that a future law repealing or amending them could be characterised as one respecting the constitution, powers or procedure of the Parliament. They included provisions about local government, the Ombudsman, and things like access to information. When questioned in Parliament about the legal basis for this entrenchment, the Victorian Attorney-General made the rather vague assertion that the, quote, weight of legal opinion absolutely supports the existence of an entrenchment power, unquote, without explaining how. It appears that reliance was placed upon what was described as an inherent power of the Parliament to reorganise itself by requiring referendums or special majorities for the passage of certain laws. This happened before the High Court's judgment in the Marquet case, which left the application of any such alternative form of entrenchment most doubtful. Undeterred, the Victorian Parliament then went on to entrench provisions that were not constitutional in nature at all. Later in 2003, it purportedly entrenched Part 7 of the Constitution Act to prevent the future privatisation of water services in Victoria. The law was passed by a special majority of 3/5 of members in each house, but that was not because of any great principle of symmetry. It was actually because in doing the entrenchment, what they were doing was amending an existing doubly entrenched provision, which required 3/5 majority in order to do it. In 2021, the same approach was taken in purportedly entrenching an anti-fracking policy in the Constitution. In 2024, the Victorian Government's at it again, with a bill before the Legislative Council to entrench government control of the SEC, a state electricity corporation, to require it to support Victoria's transition to net zero greenhouse gas emissions and to prohibit it from owning, operating or investing in a fossil fuel facility. The provision setting out the purpose of these amendments is actually quite explicit. It says that it is to constrain the power of Parliament to make laws that alter or repeal these sections to ensure that they, quote, remain in force at all times, unquote, as part of the law of Victoria. To amend them, the support of a special majority of 3/5 of the whole number of the members of each house will be required. Now, this is precisely the kind of entrenchment of a contestable policy issue that in New Zealand was regarded as contrary to convention and unconstitutional as a matter of democratic principle. In contrast to the previous legal view put by the Attorney General, the Victorian Government now argues that these provisions are supported by Section 6 of the Australia Acts 1986. How? By arguing that every law that seeks to amend or repeal an entrenched provision is a law respecting the powers or procedure of Parliament, and therefore absolutely anything can be effectively entrenched. As I explained in my previous video, in my view, this is just wrong. It's contrary to the clear intent of the provision, and it makes a mockery of the constitutional limitation that's imposed within it. But unlike in New Zealand, we've not seen the same kind of public backlash against such undemocratic action. Nor do we know for sure what a court would make of it. This brings us to New South Wales, where the Labor opposition, prior to the last election, promised to amend the Constitution to protect Sydney Water and Hunter Water from being privatised in the future. Having won the election, this was one of the first priorities of the new government. Miraculously, however, after receiving sensible legal advice, all it did was insert in the New South Wales Constitution a provision that said privatisation could not occur, quote, unless authorised by an Act of Parliament, unquote. It was just a legislative limit on executive power, which of course is perfectly appropriate. No attempt at entrenchment was made. The Premier, Chris Minns, noted that it was extremely unusual to insert a matter of policy of this kind in the Constitution. He observed that it was not something that the government takes lightly or that it intends to make a habit of. He referred to the Victorian precedent and concluded that while the government wanted to make it harder for a future government to privatise water corporations, quote, it does not want to try to preempt the decisions of future parliaments on a policy matter, unquote. Quite so. Like New Zealand, the New South Wales government accepted the democratic boundaries and did not cross them. So, a thumbs up for integrity in New South Wales and New Zealand regarding the use of entrenchment, and a thumbs down for Victoria in persisting with this abuse, regardless of whether one agrees with the particular policy it's trying to entrench or not. In my view, people should make more of a public hullabaloo about the inappropriate use of entrenchment. It's a fundamental democratic issue. Government should not be able to use temporary control of Parliament to entrench contested partisan policies. Regardless of whether these manner-informed constraints can be enforced as a matter of law, the point is that they should not be used in this way to begin with. Without pushback, governments will continue to be tempted to abuse their entrenchment power in Parliament until we get tit-for-tat entrenchments seriously damaging the operation of the democratic system. The argument that they did it so we can too is very appealing to politicians, even though you wouldn't accept that argument from a preschooler, would you? Thank you for watching the Constitutional Clarion. I hope that this video helped you to get a better understanding of this rather complex issue of matter and form and how it applies. And, as always, I look forward to seeing you next time. Goodbye.